Hello again, this is Dennis Favero. I hope that all of you are enjoying your course so far and that you're learning information about employment law. Today in this segment we're going to be discussing the Title VII of the Civil Rights Act and its overview. We'll be examining aspects that were covered in Professor Twomey's textbook, which all of you, I presume, have purchased and have been using to study for this course assignment. Let's look at the general purpose behind Title VII. As Professor Twomey noted, the purpose of Title VII of the Civil Rights Act of 1964 is the elimination of employer and union practices that discriminate against employees and job applicants on the basis of race, color, religion, sex, or national origin. We'll be discussing so-called protected classifications throughout this segment and really for the remainder of the course. Protected classifications are those classifications which the legislature has identified as being the subject of the anti-discrimination, anti-retaliation laws that seek to prohibit unfair employment practices in the workplace. When we study these various statutory laws, keep in mind what is taking place in our society and within our culture at the time. Ask yourselves, when these laws are enacted, what's taking place in our society that would prompt Congress to take action in legislating these laws that prohibit the various practices and conduct at issue. So ask yourself, for example, what's taking place in the mid-1960s that would prompt Congress and the President of the United States to enact the Civil Rights Act of 1964? Well, what comes to mind from your history and your general knowledge would be the Civil Rights Movement. So when we talk about the various legislative enactments throughout this course, keep that aspect in mind. What's taking place, for example, when the Age Discrimination in Employment Act is enacted? What's taking place in our culture, in our society, when the Americans with Disabilities Act was enacted, the Family Medical Leave Act, and so forth? And I'll be reminding you throughout these various lectures about that very feature. Always examining the civil rights laws in the context of what's taking place in our society at that various time. So turning to the legislative background of Title VII, you may have been surprised to have learned that the protected classification of sex was added to really deter the passage of the Civil Rights Act of 1964. It was an attempt by Southern senators to politically distract and avoid the passage of the enactment. In fact, it was still signed into law despite that attempt. The legislation was an idea which time had come for Congress, President Johnson at the time, and for the bill to be signed into law on July 2nd, 1964, as reported by Professor Twomey. So the legislative background should be examined with regard to the context of each of these various civil rights laws that we'll study. Let's talk about the prohibited practices and coverage. Title VII of the Civil Rights Act provides that it shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individuals, and I've highlighted that phrase. That phrase is not darkened in print in the legislative enactment. It's my own highlight to emphasize. Race, color, religion, sex, or national origin. And again, I have highlighted the word sex. I'll use this slide later for another presentation, but that's why it's been highlighted. Or to limit, segregate, classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individuals' race, color, religion, sex, or national origin. So those are the protected classifications which are identified. You'll note as we move on in this course that you're not going to see reference to harassment. That reference would be from judicial interpretation and also EEOC regulations. When we look at the statute itself, harassment, for instance, is not noted. But that would be an example where courts have interpreted and the EEOC has defined and further regulated aspects of discrimination that relate to the enforcement of these laws. So keep in mind, what is a protected classification? How do we know what is a protected classification? Well, we examine the law. We examine the source of where that law is identified and how it originates. For example, Bob, who was fired in our last example in the previous session, was told that he was fired because he was wearing a blue sweatshirt. Wearing a blue sweatshirt is not a protected classification. So always examine what is a protected classification. And we'll discuss this in just a moment as well. There are various state laws which also regulate employment practices in respective states. In Illinois, for example, we have the Illinois Human Rights Act. And I wanted to give you the definition of unlawful discrimination as it is provided within the Illinois Human Rights Act. Just by way of comparison, and again, we'll talk about this in more detail momentarily, but for now, let's examine what the definition is. The Illinois Human Rights Act defines unlawful discrimination as discrimination on the basis of race, color, religion, national origin, ancestry, age, sex, marital status, order of protection status, disability, military status, sexual orientation, pregnancy, or unfavorable discharge from military status. The Illinois Human Rights Act provides that it is an unfair discriminatory practice of employment for an employer to refuse to hire, to terminate, segregate, or to act with respect to recruitment, hiring, promotion, renewal of employment, selection for training or apprenticeship, discharge, discipline, tenure or terms, privileges, or conditions of employment on the basis of an unlawful discrimination or citizenship status. You'll note from reading that definition that it's more narrowly defined in terms of the scope than Title VII, but certainly borrows from the provisions and the overall purpose. With regard to Title VII and the various anti-discrimination laws, which we'll study in detail throughout this course, the covered employer should be also defined. Who is the employer, for instance, that is going to be covered or subject to the regulation of these enactments? Private and public employers are going to be a covered employer. Unions are also covered within the scope of these anti-discrimination laws, as are employment agencies. Now let's talk about the continuum of an employment relationship in the context of anti-discrimination laws. And I put together this a chart or exhibit, and I've noted the aspects of hire and separation. So if we look at the beginning of an employment relationship, you might think that it starts when the employee is hired. And that would be true. And you might think, well, when does it end? Upon separation. One could be terminated, one could voluntarily leave, one could retire, but there would be a beginning and an end to the employment relationship. These anti-discrimination laws, which we'll study, including Title VII, cover not only the beginning and the end of the employment relationship at hire and separation, but also pre-hiring and post-employment aspects. Title VII reaches pre-hiring, which we'll study, and you'll read some cases about later in this section. And in the weeks to come, that Title VII will regulate what takes place and attempts to even hire the employee, and of course what takes place after the employment relationship ends that still could lead to liability against the employer for conduct or actions taken. If you'll look at the course syllabus, the way it's organized, we'll actually be studying pre-hiring considerations later in the course. Now you may question, well, why is that? Why are we waiting till the end of the course to examine pre-hiring considerations? Why not start at the beginning as it would ordinarily follow? Well, we're going to study these employment laws and understand how they regulate the employment relationship so that when we examine how the relationship even starts and before, how these laws will apply. You'll also note in this chart the terms of compensation, terms, conditions, privileges. Those aspects are covered by these anti-discrimination laws. In other words, these laws reach to impact how compensation occurs. What are the terms? What would be an example of a term or condition of employment? What about promotions, demotions, suspensions, pay raises? Anything that takes place between hire and separation will form the terms, conditions, and privileges of employment. Being transferred to another division, being denied an opportunity, anything that takes place that may create a so-called adverse impact or consequence on the basis of anti-discriminatory treatment will be framed within this context of compensation, terms, conditions, privileges. And in fact, those terms, or I should say that language, is borrowed from the definition of Title VII. Let's just for a moment consider how Title VII might reach post-employment aspects. Let's say, for example, that Jane files for a discrimination charge at the EEOC while she's employed. Can that occur when one is still employed, the filing of a charge at the EEOC? Well, the answer is yes. One does not have to be separated from employment and thereafter file a timely charge of discrimination. One could still be employed and contact the EEOC and have a charge filed, processed, and investigated. Let's say that while Jane was employed, that charge had been filed, was investigated, and that a resolution was achieved between she and the employer. After Jane left employment, she listed company ABC where she worked and where the employer against whom the charge had been filed on a job application as a potential reference. That prospective employer contacted ABC Inc. and was given a very bad reference about Jane's employment, and in fact may have been specifically told that Jane exhibited poor performance throughout her employment. Now, if that was true, that may be permissible, and we'll talk about that later in this course, about what could be said or how things can be communicated after the employment ends with respect to job references or inquiries. But let's assume that Jane was a very good employee with a history of exemplary performance and a record of favorable reviews. So it would be untrue that Jane would be a poor performer, especially if she left on her own and left for reasons unassociated with any type of performance matter. Having filed the charge of discrimination while she was employed, and if the employer chose to present a negative or false job reference, could be an example of retaliation. Is retaliation a covered practice within the framework of these anti-discrimination laws? The answer is yes. And we'll talk about other post-employment aspects later as we move along the course. Just a short other example, let's say that there is a separation that occurs for many employees, and the separation is based on a reduction in force, a business-related reason to end employment on the part of the employer toward that employee or those respective employees' jobs. If, for example, the separated individuals were offered severance as a transitionary amount of money, and the severance offers were not based on equitable or fair provisions. Let's say, for example, that older employees who were there longer received less severance than younger aged employees, or male employees, for instance, received more severance compensation than comparable female employees. Well, that would be post-employment conditions or privileges that might reflect a discriminatory practice. Would that be covered within the framework of these anti-discrimination laws? Of course that practice would. Let's look at statutory coverages. And there's going to be a handout that I'm going to direct your attention to on Blackboard. Let's take a look at this handout. You're going to note it's a chart that's entitled Where to File Employment Discrimination Claims. On the top of the chart would be agencies to contact, and as we move to the right, there's different segments: Chicago Commission on Human Relations, Cook County Commission on Human Rights, Illinois Department of Human Rights, U.S. Equal Employment Opportunity Commission. Please retrieve that chart if you haven't already, and we'll be talking about these different divisions momentarily. With regard to the Equal Employment Opportunity Commission, that is an agency that originated through Title VII. When Congress enacted Title VII, Congress also formed by law the EEOC to administer and to investigate alleged violations of these anti-discrimination laws. There's a section in your textbook beginning on pages 398, 399, and 400 that specifically relates to the EEOC, the Equal Employment Opportunity Commission. Turning to the chart, and we're going to start from the right-hand column and move to the left. You will note that the protected classifications under Title VII have been identified: race, color, religion, sex, national origin, ancestry, which would relate to the national origin, age, disability, and retaliation. Those are the protected classifications that the EEOC has the authority or jurisdiction to regulate, administer, and investigate whether there are violations. Compare that listing to the listings of identified protected classifications as we move to the left of that chart. Next would be the Illinois Department of Human Rights. Now you will note that there are many more identified protected classifications. Classifications that the Illinois legislature has chosen to protect, such as unfavorable military discharge, military status, retaliation, aiding, abetting, willful interference, coercion, arrest record. Now, there might be applicable laws that we'll, of course, study later in this course that also relate to those aspects of the employment framework. However, the EEOC does not have direct jurisdiction to investigate and to administer those areas. The difference is that the Illinois Department of Human Rights would, however, have such authority under state law. Now, many states have human rights or human ordinance types of laws, human rights types of laws, and administrative agencies to administer them. Some states do not. Location must always be considered when we examine what rights are available and obligations are undertaken by employers with respect to employee workforces. Turn to the column next where is noted Cook County Commission on Human Rights. Again, you'll see many protected classifications that are identified. If an employer is situated in Cook County, which of course is in Illinois, and would be also regulated by the EEOC if there are sufficient employees working, then these agencies would have jurisdiction over any alleged violation of these categories. If the employer is located also in Chicago, then these various agencies would all have jurisdiction to investigate alleged violations of these identified protected classifications. You'll note the geographic limitations, which are noted on this chart. Where the violations occurred has to be considered. Let's move next to the time limitations. Very important consideration, and let's talk about this in some detail. And I want to give you a framework to consider. You may already know this, you may not. But let's talk about statutes of limitations. What are statutes of limitations? They're a designated time frame established by a respective legislature regarding when or how long a claim may exist for timely preservation to make sure that the rights are covered. Let me give you an example. In our jurisdiction here in Illinois, there is a 2-year statute of limitations which the legislature has enacted to file a claim for a personal injury. If one is injured in an auto accident, the legislature has said you've got 2 years in which to file a timely action. If the accident occurred in 2016 and the plaintiff filed the lawsuit in 2020, it would be untimely. That action would be barred by the statute of limitations. So for personal injury matters in this jurisdiction, there's a 2-year statute of limitations. What about a written contract? If there's a breach of a written contract in this jurisdiction, the legislature has established a 10-year statute of limitations. 10 years. If one has entered into an oral or verbal or an implied contract, what's the statute of limitations? 5 years. If someone has been defamed and has a defamation action to pursue, what's the statute of limitations? 1 year. If someone's been the victim of fraud or misrepresentation in the civil context, what's the applicable statute of limitations? 5 years. If someone in this jurisdiction was a victim of a violation of privacy and their privacy rights were violated, what's the applicable statute of limitations? 1 year. Okay, that's the framework or the backdrop of statutes of limitations for various civil causes. Turning your attention to the statute of limitations with respect to civil rights violations. What's the applicable time frame? 180, and in our jurisdiction, 300 days. A much shorter, much narrower time frame in which to timely preserve one's rights by commencing an action. That's a very short time by comparison to the other civil causes that I've just identified. You'll note in your textbook that timely filed charges of discrimination must be submitted to the EEOC within 180 days. Now, in this chart, you'll note that there is a 300-day period for the alleged violation time frame. States that also have their own respective Department of Human Rights or a respective human rights or fair employment agency are known as deferral states. And by rights, citizens within those jurisdictions have up to 300 days to file a charge that's timely with the EEOC. Now, as our state is a so-called deferral state, a timely filed charge has to be made within 300 days from the alleged violation. So let's just say, for example, that Bob is fired on January 1st. If Bob files an action on December 30th of that year, would it be within a 300-day time limitation? The answer is no. So if Bob is seeking the EEOC's efforts to investigate and his rights to be timely preserved, that charge must be submitted within 300 days. Otherwise, it's barred by the statute of limitations. So timing is a factor. But let's go back to the question asked earlier. Why such a short time frame? Perhaps it's because Congress wants to address civil rights violations quickly. And it wants to encourage individuals who are victims of civil rights violations to seek action soon to end whatever has taken place that's unlawful, to allow the agency time to investigate quickly these alleged violations so that remedies can be available. Why not allow for 3 years or 4 years or up to 10 years? Again, there's a high emphasis that's placed by policy from Congress to address these violations early, quickly, and thoroughly so that the civil rights violations, if any, can be resolved and properly remedied. That's certainly a reasonable explanation for the time frame that is such a very narrow element in preserving rights and claims in this context. Okay, let's look at who can be sued. And as we're moving further on this list, you'll see that only certain employers that have sufficient employees have coverage under these respective laws. For the EEOC jurisdiction for coverage under Title VII and the ADA claims, and we haven't discussed this yet, and claims under the Age Discrimination and Employment Act, which we'll discuss here in the weeks to follow, 15 and 20 employees must be employed by the employer in order for these particular laws to have any coverage and for the EEOC to have jurisdiction to administer and investigate. Why, for example, would 15 be the requisite identified number in order for these laws even to apply? That's a question. Well, that question is what Congress addressed back in the 1960s. That's what the law is, as decided by Congress, and that's where the coverage applies. Now, you'll note, however, that if you look at these other agencies, the Illinois Department of Human Rights or the Cook County Commission on Human Rights, the Chicago Commission on Human Rights, what number of employees are covered with respect to those particular laws? 15? Yes. However, you'll note that in Illinois, under the Illinois Human Rights Act, there is coverage for sexual harassment, pregnancy discrimination, and disability discrimination where the employer has only one employee. What does that suggest? Well, it suggests a high priority policy determination made by the state legislature here in Illinois, that these particular aspects of civil rights laws will be certainly examined and will allow for coverage even when other areas would not for the requisite number of employees. So a high priority is given by the state legislature in this jurisdiction for matters involving sexual harassment, disability discrimination, and now pregnancy discrimination. You'll note with the Cook County Commission on Human Rights and the Chicago Commission on Human Relations how many employees are required for there to be jurisdiction under those laws. Only one. Let's talk a little bit more in detail about identifying these various agencies in which discrimination charges can be filed. Why, for example, would an employee want to select the Illinois Human Rights Act to use as opposed to the U.S. Employment or U.S. Equal Employment Opportunity Commission with Title VII and so forth. Well, timing can be a factor. If a timely filed charge is not made, then certainly that's a consideration. If, in other words, it's beyond the 180-day time frame, but still within a 300-day time frame, and there's enough employees employed by the covered employer, then the EEOC may be the only choice in which to preserve one's rights. In Illinois, there is a working relationship between the Illinois Department of Human Rights and the EEOC. If a charge is filed at the Illinois Department of Human Rights within 180 days, which would make it timely under its jurisdiction, then by way of a work sharing agreement with the EEOC, that charge is cross-filed at the EEOC. The effect is that both state and federal rights would therefore be timely preserved. Now, based on that work sharing agreement, the EEOC, if it first receives a charge and that charge is submitted within 180 days, it will cross-file a timely charge with the Illinois Department of Human Rights so that that individual's state and federal rights are both timely preserved. Now, with respect to the Cook County and the Chicago Commission on Human Rights, there is no such applicable work sharing agreement. Let's turn to the second page of that handout. And you'll note on the very top that there's the kinds of relief available. Make whole damages are referenced on each category. What would be considered as make whole damages in this context? In other words, the objective, if these laws are properly applied in terms of coverage and remedies available, the objective is for the injured employee to be made whole, to put that employee back in a position but for that alleged unlawful, discriminatory, retaliatory treatment. Make whole damages may include back pay, lost benefits, emotional distress damages, compensatory damages, injunctive relief, as well as attorney's fees for the prevailing plaintiff. In your textbook, you're going to find on page 409 a chart that identifies the various forms of remedial relief available under Title VII. And we have already talked about in the last segment the two theories of discrimination, and at that time I said that we would have more of a discussion about same later. Well, that later is right now. There's two theories, and it's also identified in your textbook: disparate treatment theory and disparate impact theory. And those two theories have present a huge difference in terms of the available remedies for violations. Let's look at the disparate treatment theory. That involves proof of discriminatory treatment. It involves a disparate treatment. What's disparate treatment? Discriminatory treatment, treatment that is intentional. Each party has a right to require a jury trial when compensatory or punitive damages are sought. Now you'll note that with the Cook County Commission on Human Rights and the Cook the Chicago Commission on Human Relations, those agencies do not provide for any mechanism whereby a jury trial would be available to address the alleged violations. Under federal law, when a timely filed charge of discrimination is made, after that process with the EEOC has concluded, one has a right to present the claims to a judge and a jury. In Illinois, the individual claimant has a similar right after the process has been exhausted. Those same opportunities for a jury trial are not available for the Chicago Commission on Human Relations and the Cook County Commission on Human Rights. So in terms of making a choice wherein to preserve one's rights and have claims investigated, employees need to consider what are the remedies, what are the available damages, and how can those damages be presented in what judicial framework. Let's look at the remedy under the disparate treatment theory. The remedy would be reinstatement, hiring or promotion, back pay, less interim earnings. We talked last segment about the duty to mitigate. An employee has an obligation under law to seek replacement work. In other words, if Bob was allegedly wrongfully fired in violation of his rights under Title VII, he cannot sit back and do nothing until the time when trial occurs and a jury awards money based on the damages that have been sustained. Bob is required to, by law, mitigate damages by seeking alternative replacement work. So back pay is available less interim earnings. Retroactive seniority is also an available remedy. So if someone was a victim of discrimination by a failure to promote, retroactive seniority and any economic or monetary consequence of that failure to demote, or failure to promote, I should say, could be an awarded remedy under Title VII and as well as these other civil rights laws. Attorney and expert witness fees are also available to the prevailing plaintiff. You'll probably ask, well, if the plaintiff loses, does the defendant employer get its attorney's fees awarded as a matter of right? The answer is no. Congress encourages the so-called vindication of rights by an employee, and the awarding of attorney and expert fees and cost is encouraged and available by the so-called vindication effort undertaken by an employee to preserve their rights and to seek remedies for rights violations. In other words, Congress has encouraged employees to take action where their civil rights have been violated and are rewarding a successful attempt to do so by making available reimbursement of attorney's fees and expert witness fees as a matter of right. Compensatory and punitive damages. Let's talk about those aspects for just a moment as well. There are caps on damages. Size, again, makes a difference with respect to not only liability and the coverage under these particular laws, but also the availability of damages. Employers that have 500 or more employees have a so-called cap of damages limited to $300,000. Employers that have 201 to 500 employees, they are capped at damages of $200,000. So let's say, for example, a jury awards Bob or Jane $600,000 in compensatory damages. Can the jury do that? Yes, a jury could. A jury is not going to be instructed, however, as to the statutory cap imposed on its award of damages. The judge will apply that cap thereafter because Congress has provided that there is a limitation on these types of damages. And Congress has also determined, as a result of the amendment to Title VII in 1991, that the number of employees makes a difference as to the application of these caps on damages. You'll note that there's no cap on damages for race cases. Compensatory damages include future pecuniary loss or non-pecuniary loss, such as emotional pain and suffering. So these caps will not relate to economic loss, but compensatory damages, which would be for pain, suffering, emotional distress, embarrassment, humiliation, those types of damages, along with punitive damages, are subject to the cap. The cap does not cover, however, economic loss sustained, such as back pay. You'll note the difference for the available remedies regarding disparate impact. Disparate impact involves a facially neutral practice or neutral application. There's no intent required. Now, you'll also see that there's no right to a jury trial either. The remedy would be reinstatement, hiring or promotion, back pay, less interim earnings, retroactive seniority, attorney and expert witness fees as well. Let's talk about the difference between harassment and discrimination. Those are terms. While there are similarities between discrimination and harassment, there are distinct differences. Discrimination involves a comparative analysis between an individual or a group of people who are treated less favorably than another person or group on account of their legally protected classifications. For example, race, color, religion, gender, age, disability, marital status, or sexual preference. A protected classification must first be identified to determine whether such treatment and/or policy impact may be illegal. Harassment occurs when an individual is made to feel intimidated, insulted, humiliated because of a protected characteristic. For example, ethnicity, color, gender, race, sexual preference, age, or disability. Again, identification of legally protected classifications must be made in order to determine whether such offensive conduct is applicable within the meaning of those prohibitions. Title VII, of course, addresses harassment and discrimination as well as retaliation. Retaliation occurs when an individual opposes or participates in legally protected conduct or activities and suffers adverse reprisals. Both harassment and retaliation fit within the overall context of discrimination laws. Finally, let's talk about the Civil Rights Act of 1866. And I'm going to ask you to turn back to your textbook on page 395. Professor Twomey notes that numerous major federal laws regulate the employment rights of individuals. The Civil Rights Act of 1866, commonly referred to as a legal action under Section 1981, remedies discrimination based on race. 1866. What has taken place, or what was taking place during that time frame in our history and in our culture? Now keep in mind, 1866 is what, 98 years before the Civil Rights Act of 1964 that addresses discrimination with respect to workplace matters. what's taking place in our culture back in the 1860s? Well, the Civil War. The Civil War ended in 1865. And after the end of the Civil War, Reconstruction of the South from the devastation of the Civil War was taking place. What did Reconstruction, so-called, include? The rebuilding of the South. Contracts, services, labor, anything to deal with the rebuilding efforts that was necessary. How does that apply to race? Well, Congress at the time passed a law with respect to the making and enforcement of contracts that had a race aspect. The section 1981 is a modern codification of the Civil Rights Act of 1866. The objective of that law was to prohibit discrimination with respect to race in the making and enforcement of contracts. How does that relate now to the employment context? Well, we learned last week that contract law makes up employment law. In fact, employment law's origin depends upon contract law. If the making and enforcement of contracts that prohibited race as a factor, even back in 1866, would race be a factor in the prohibition of contracts today with respect to employment, even in an at-will context? The answer is yes. Courts have said that even at-will employment will be subject to the applications of the Civil Rights Act of 1866, now codified in 1981. Courts have also said that the Civil Rights Act of 1866, or 1981, as it's now referenced, applies not only to race, but also origin and color. Now, with respect to the Civil Rights Act of 1866, 1981, section, no EEOC charges are required. Well, what does that mean? It means that an individual who believes that they have been discriminated against in violation of this particular law doesn't have to go through the EEOC. They have a direct path to litigation if the claim involves race, origin, or color discrimination, harassment, or retaliation. Now, what's the advantage or disadvantage? Well, the advantage to the EEOC process would be an investigation that's undertaken. That investigation is paid for by taxpayer dollars. Without that advantage, the employee would be required to discover facts through the available means of court procedures. Those facts that could lead to liability under Title VII, administered by the EEOC, would be undertaken by the EEOC investigative process. That investigative process would be lost if the charge was not timely filed, of course, to preserve one's rights. Instead, the plaintiff employee would be required to file a lawsuit and then commence litigation at their own expense. Let's look at another notable difference between Title VII and the Civil Rights Act of 1866. Title VII requires, for how many employees? For applicable coverage, 15. The Civil Rights Act of 1866 only requires one employee for there to be applicable coverage. There's a longer period of limitations as well. The EEOC limitation period for preserving rights under Title VII would be 180 days in some jurisdictions. In our jurisdiction, for example, it's 300 days. The jurisdictional time frame for a timely filed charge under Section 1981 timely filed lawsuit, not a charge, timely filed lawsuit is 4 years. There's also no caps on damages. So a company that employs 15 employees, if subject to Section 1981 coverage, and if there is liability found against it by a jury, the damages are uncapped. So those are all features to consider with respect to race, origin, and color. By contrast, going through Section 1981 from the available remedies under the Title VII administered by the EEOC. There's a lot of information that was covered in this segment's discussion. This is all covered in your textbook as well. And I've included some course materials that give you a much broader context and application that is entitled Harassment, Retaliation, and Discrimination, Rights and Reprimands. There's a lot of information in that handout, and also discusses theories of discrimination applicable to federal law in much more detail, as well as other aspects of these civil rights laws, which, again, we will cover in detail throughout the remaining sessions and course coverage. Thank you.